Series that is so generously sponsored by the Einhorn Family Foundation. So I want to thank Steve and Nancy Einhorn. I also want to thank Senator Rand Paul. He has been the inspiration for this lecture series for, I think, 8 or 9 years we've been doing this, and we're getting great crowds and wonderful speakers. I'd also like to thank Randy Barnett for coming today. He is a good friend of the Fund for American Studies. He helped inspire the creation of our Law Fellows program, and I hope that any of you who end up going to law school will consider that program. Now it's my pleasure to introduce our introducer. She's a student in the Fund for American Studies program. She's Annalise Cahill. She attends Xavier University in Cincinnati, and she's a native of Crescent Springs, Kentucky.
Hi, how's everyone doing today? Good, yeah, I hope you all are well. So it is my pleasure to introduce Mr. Randy Barnett, and I can think of no better way to wrap up our final week in Washington, D.C. I'd like to start by thanking the Fund for American Studies and Senator Rand Paul for hosting the interns for the summer lecture series. We really appreciate it. So Mr. Randy Barnett is the Patrick Hotung Professor of Constitutional Law at the Georgetown University Law Center. He's been awarded the Guggenheim Fellowship in Constitutional Studies, the Bradley Prize, and is currently a senior fellow at the Cato Institute. He's been published in over 80 articles, several novels, and now contributes to the Federalist Society, covering a range of topics from federalism and the separation of powers to criminal law and procedures. So with that, please join me in giving a warm welcome to Mr. Randy Barnett.
Turn on one of these mics they gave me here. All right, everybody hear me okay? Okay, I can see you all fine. Thanks so much for that introduction. And actually, where did my introducer go? Oh, there she is. It's not you, it's you. All right, thank you very much for that. Thank you, Senator, for having me back again. I think this is probably the third time I've been here, the second time in this room. And it's good to look out and see all of your bright, shiny faces. I guess this is your last week, is that right? Is that what she said? So you got to head back to wherever you're going. All right, well, let me give this talk. It starts with a story. When I was 13, I played clarinet in the Hoover Shrum Grade School Band of Calumet City, Illinois. By the way, anybody here from Illinois? Okay. We routinely toured the Midwest, playing county and state fairs. In 1965, the band traveled to New York City, where we performed at the Kiwanis International Convention at the old Madison Square Garden. So I can actually say that I played the garden. We played another concert at the New York World's Fair, held in Flushing Meadows on that trip. Now, one of the wonders of that fair was a show featuring an animatronics figure of Abraham Lincoln, designed by Walt Disney, who rose to his feet from his chair to give a short speech, composed of lines from an amalgam of Lincoln speeches set to stirring music. That animatronic figure of Lincoln eventually became the centerpiece of the Hall of the Presidents exhibit at Disneyland and Disney World, a multimedia presentation and stage show featuring audio animatronic figures of all 45 individuals who have served as President of the United States. How many of you have seen the Hall of the Presidents show at Disney World? Right. Well, that started with the one figure about Lincoln in the New York World's Fair. That's what started that. Now, I was so moved by this performance that I purchased a souvenir record of Lincoln's speech that I would play on my record player at home and repeatedly. The Disney writers began with this passage from Lincoln's 1854 speech at a sanitary fair. The world has never had a good definition of the word liberty, and the American people just now are much in want of one. We all declare for liberty, but in using the same word, we do not all mean the same thing. Lincoln, in his actual speech, then posed two opposing definitions of liberty. Quote, with some, the word liberty may mean for each man to do as he pleases with himself and the product of his labor, while with others, the same word may mean for some men to do as they please with other men and the product of other men's labor. Here are two not only different but incompatible things called by the same name, liberty. And it follows that each of the things is, by the respective parties, called by two different and incompatible names, liberty and tyranny. But the Disney writers omitted this definition of liberty and moved instead to the following passage of Lincoln's 1858 speech at Edwardsville, Illinois. And by the way, you can go on YouTube and just search Lincoln animatronics, and you can get videos of the actual Lincoln speech from the New York World's Fair. They're up on YouTube. So here was the next excerpt they used. What constitutes the bulwark of our own liberty and independence? It is not our frowning battlements, our bristling seacoasts. These are not our reliance against tyranny. Our reliance is in the love of liberty, which God has planted in our bosoms. Our defense is the preservation of the spirit, which prizes liberty as the heritage of all men, in all lands, everywhere. Destroy this spirit, and you have planted the seeds of despotism around your own door. Now, you can only imagine how these quotes resonated with a 13-year-old conservative and future libertarian who, just the previous year, had debated on behalf of Senator Barry Goldwater before the entire student body of his grade school. To this day, I remember hearing what for me was its most memorable line, which years later I learned was taken from Lincoln's 1838 speech to a young man's lyceum of Springfield, Illinois. And here is how it goes. At what point shall we expect the approach of danger? By what means shall we fortify against it? Shall we expect some transatlantic military giant to step the ocean and crush us at a blow? Never. And this is the line that gets me every time. All the armies of Europe, Asia, and Africa combined could not by force take a drink from the Ohio or make a track on the Blue Ridge in a trial of 1,000 years. I still get chills. I'm getting chills right now, just from reading that line. Then Lincoln continued, at what point, then, is the approach of danger to be expected? I answer, if it ever reach us, it must spring from amongst us. It cannot come from abroad. If destruction be our lot, we must ourselves be its author and finisher. As a nation of free men, we must live through all times or die by suicide. This, I submit, is the danger now confronting what Lincoln called the American, quote, political edifice of liberty and equality rights. It is a danger from within, a danger posed by the rise of the concept of social justice and the narrative of wokeness within virtually all of our elite institutions, within our schools, our media, our churches, our synagogues. By social justice, I mean the notion that as persons we are constituted first and foremost by the groups to which we are members from birth, and that justice is to be measured by and afforded to these groups rather than to us as individuals. By wokeness, I refer to the narrative that imagines the American story as one of dominance and oppression by one group over all the others, an American narrative that is to be repudiated and destroyed rather than embraced and preserved. This is why our story must be expunged from our schools, and the statues of Washington and Lincoln must be removed from our public spaces. In this talk, I will not critique these two insidious notions. Instead, I want to engage in a bit of self-criticism by offering two observations about the conservative legal movement in which, for example, the Federalist Society is a driving force. Since its founding in the early 1980s, the Federalist Society has explicitly been a coalition of political conservatives and political libertarians who made common cause to preserve and protect and defend the Constitution of the United States. This was the movement, the coalition, to which I committed myself some 35 years ago and to which I am committed today. In these remarks, my goal is to identify how this movement, as a movement, has been deficient in our efforts and how we, as a movement, can do better. Doing so is going to require me to make some generalizations about some conservatives and some libertarians that will not apply equally to everyone. My first observation concerns how better to counter claims of social justice, and my second concerns how to better counter wokeness. First, to counter social justice, conservative constitutionalists need to spend more energy on the concept of justice. In particular, they need to focus on the conception of justice that is defined by natural rights, which were affirmed at the founding in the Declaration of Independence. It is no accident that my first book, The Structure of Liberty, Justice and the Rule of Law, was an explication and defense of the liberal theory of justice. In my experience, because they not unreasonably fear judges making up and enforcing rights, some conservatives tend to poo-poo justice altogether. For example, when discussing the Declaration, some conservatives like to stress its affirmation that governments derive their just powers from the consent of the governed. At the same time, they tend to overlook or dismiss the importance of the first part of that sentence, which says, "To secure these rights, governments are instituted among men." Which rights were these? They were the unalienable, natural, and individual rights to life, liberty, and the pursuit of happiness. Each one of those rights belong to us as individuals, not to us as members of a group. Indeed, some conservatives de-emphasize the role of the Declaration altogether, going out of their way to insist that the Declaration is not law. This was recently done by Justice Barrett in her confirmation hearing. In response to a question by Senator Ben Sasse about the role of the Declaration, she responded with this, quote, "The Declaration of Independence is an expression of our ideals, an expression of our desire to be free from England. It is not law, however. The Constitution is law. It is our governing document. While the Declaration tells us a lot about history and the roots of our republic, it is not binding law." And can I get a glass of water or something? Thanks. My point is not to single out Justice Barrett for special criticism, nor even to disagree with her claim about what is law. I quote her, thanks, because this instinctive diminution of the Declaration as our founding document is a fixture of thought for some conservatives. And it's such a fixture of thought that it just rolled spontaneously and smoothly and eloquently off her tongue. She was not prepared. That was not a prepared answer. That was just how she felt. The case of Troxell versus Granville provides another example. In that case, a majority of the court upheld the fundamental right of parents to raise their own children. Let me say that again. The fundamental right of parents to raise their own children. That is not a right that you see enumerated in the Constitution. Is it not a fundamental right of Americans? But it's not in the Constitution. In his dissenting opinion, the court upheld that right. In his dissenting opinion, Justice Scalia, for whom Justice Barrett clerked, conceded that this right was one to which both the Declaration and the Ninth Amendment refers. He wrote, quote, "In my view, a right of parents to direct the upbringing of their children is among the inalienable rights with which the Declaration of Independence proclaims all men are endowed by their Creator. And in my view, that right is also among the other rights retained by the people, which the Ninth Amendment says the Constitution's enumeration of rights shall not be construed to deny or disparage. The Declaration of Independence, however, is not a legal prescription conferring powers upon the courts, and the Constitution's refusal to deny or disparage other rights is far removed from affirming any one of them, and even further removed from authorizing judges to identify what they might be and to enforce the judges' list against laws duly enacted by the people." In contrast, Justice Thomas, where is that going to be safest? Maybe there. In contrast, Justice Thomas joined the majority and even argued for strict scrutiny. I suspect this de-emphasis of justice and natural rights stems from a preoccupation with the portion of the Federalist Society mission statement that says, quote, "It is emphatically the province and duty of the judiciary to say what the law is and not what it should be." This preoccupation comes at the expense of that part of the mission statement that insists that the state exists to preserve freedom. This singular focus on the proper role of judges at the expense of the liberal conception of justice based on the natural rights that define freedom or liberty is analogous to advocates of the free market who focus entirely on its efficiency rather than on its morality and justice. And recently, we've witnessed an insurgency in the conservative movement by those who critique the individual natural rights foundation of the American theory of government and advocate what they call a common good conservatism that is highly critical of what they disparagingly label as individualism or liberalism. A few of these advocates have even turned on the Federalist Society's commitments to promoting adherence to the original meaning of the Constitution itself. Now, of course, my criticism does not apply to all conservatives, and I share the conservative skepticism of judges implementing natural rights. I do not advocate that, and I never have. But such skepticism is entirely compatible, skepticism about judges is entirely compatible with a serious treatment of just how the structural constraints of the Constitution further work to advance substantive justice based on natural rights. Furthermore, this tendency to focus on the law as it is rather than as it ought to be cedes the moral high ground to those who today place conceptions of social justice above both the natural rights of the individual and the original meaning of the text of the Constitution. In my view, social justice is not justice properly conceived. However, without a grasp of natural rights, why they are so imperative, and how the structures provided by the original meaning of the Constitution work to secure these rights, conservatives are unable clearly to explain why it is that social justice conflicts with real justice. A majoritarian or positivist conception of popular sovereignty, in which the might of the majority is seen to make right, a conception that many conservatives hold, has a difficult time responding to moral appeals to social justice. That is why I was moved to write my book, Our Republican Constitution, Securing the Liberty and Sovereignty of We, the People. In that book, I distinguish between the collective or democratic conceptions of popular sovereignty, which is based on implementing the will of the majority, and the individual or Republican conception of popular sovereignty, which is based on securing the individual natural rights of we the people, each and every one. Now, my second observation has to do with wokeness. In my experience in the conservative and legal movement, I have found that some conservatives stress the Federalists and the founding in the 18th century, while diminishing the importance of the Republican Party in the 19th century. These Republicans in the 19th century were responsible for ending slavery. After slavery's end, they fought against white supremacy in the South and also in the North. Before being overcome by terrorist resistance in the South and political exhaustion in the North, these Republicans fought tirelessly to protect the freedmen, reconstruct Southern state governments to ensure that they were truly Republican, and ensure an equality of civil rights North and South. They did so not by adopting a living constitution, but by enacting formal constitutional amendments, which empowered them to enact a series of federal civil rights laws. These amendments and these laws applied to the nation as a whole, not just to the South. But in cases like the slaughterhouse cases and the civil rights cases, the Supreme Court soon gutted these amendments and these laws by employing a mixture of original intent and living constitutionalist methods. This eventually culminated in the ultimate application of judicial restraint, Plessy versus Ferguson. As a result, white supremacy survived and thrived in this country for decades after it had been declared unconstitutional by written amendment and illegal by congressional enactment. When interpreting the 14th Amendment, the preoccupation of some conservatives with judicial restraint has led them to deprecate its privileges or immunities clause. The Privileges or Immunities Clause says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. You would think that was pretty important, wouldn't you? But as of 1873, it plays no role whatsoever in constitutional law because of a case called the Slaughterhouse Cases that basically interpreted it as a nullity. These same conservatives also fail to acknowledge that the due process of law requires that the substance of laws be within the just powers of legislatures to enact. And they also favor extending what's called the state action doctrine beyond the Privileges or Immunities Clause and Due Process Clause where it applies to the Equal Protection Clause, where there's good reason to believe it does not apply. That is, the Equal Protection Clause not only protects us against state action that's discriminatory, it protects us against state inaction. It guarantees protection of the law. That's what it was there first and foremost to do, to ensure protection of the law, which was being denied in important parts of the country. Now, this systematic de-emphasis of the anti-slavery origins of the Republican Party, the civil rights laws and amendments that it enacted, and the efforts of Republican administrations to enforce these provisions, in particular the Grant administration, has resulted in a failure to provide a positive contra-narrative to the woke left. In this regard, I've been influenced by my years-long study of anti-slavery constitutionalism, which was deeply informed by natural rights. It was anti-slavery constitutionalism that was informed by natural rights. In the beginning, I studied anti-slavery constitutionalism because I found it to be inherently interesting. It just appealed to me to read it. Now, I find it to be imperative. Yet it is a narrative too few in the conservative legal movement are aware of or appreciate. My own constitutional law casebook is organized around these themes and emphasizes how slavery was ended, as well as how equality and civil rights was thwarted by the Supreme Court's passivity in the face of massive democratic resistance. This is not, I should stress, a narrative of triumph. It is a narrative of tragedy. But it is a narrative of progress, which honors the struggles and heroism of our ancestors on behalf of liberty and equality, rather than excoriating them as knaves and as villains. I find that this narrative completely disarms students who come to my class with a woke narrative in mind and who expect a certain kind of narrative from me that they simply do not get. Class discussions have an entirely different tenor than they have in the absence of this narrative being carefully developed in the first third of the course, not tacked on as an afterthought. Just the other day, a student with an Obama poster on his wall told me during a Zoom office hours that he came to my class hostile to originalism, only to be surprised by the original meaning of the 14th Amendment. Now, this happens every semester. With the publication of my book this fall, The Original Meaning of the 14th Amendment, Its Letter and Spirit, you will better be able to see what I mean. It's coming out November 2nd. To conclude, by spending more time on substantive justice at the founding, and the fight by Republicans against slavery and white supremacy after the founding, conservatives can do much to displace the left from the moral high ground it has successfully claimed in our elite institutions. In short, we have a better case to make than we have been making, and we have a better story to tell than we have been telling. Thank you. You got to go?
Now, I'm going to take the prerogative of the first question.
First question. Here's the mic. You want to use the mic?
I was always fascinated when I started reading your books about this whole idea of judicial restraint versus activism. And I'll ask young conservatives, are you for judicial restraint? And everybody raises their hand. And yet it's I think as most contrarian positions are, it's a little more complicated than that. And so when he said Plessy versus Ferguson was upheld this terrible idea actually that we should be separated and we could somehow be equal to be separate, was judicial restraint. Conservatives were not for that. We shouldn't be. But there was so much where the court's actually active in overturning bad things that's actually good, at least from the liberty perspective. But could you just expand a little bit more on judicial restraint versus judicial activism versus the term you like to use, engagement?
Right. Thanks so much, Senator, for that. The term judicial activism, so far as we know, was coined in 1947 in a magazine article in Fortune magazine by a historian named Arthur Schlesinger Jr., who was a Harvard historian, a New Dealer, someone who actually ended up being kind of influential in the Kennedy White House later on, in Camelot, as they used to call it. At any rate, he was doing a profile on the justices, and he saw how the New Deal justices were starting to break down amongst themselves into two camps, with a middle camp in between. On the one camp, he said there were the lions of judicial self-restraint, like Felix Frankfurter. On the other hand, he said there is this judicial activism that's associated with the legal realist movement of the Yale Law School. He didn't mention, because he was from Harvard, that the restraint guys were kind of from Harvard and the activism guys were kind of from Yale. So there was a bit of a Harvard-Yale split going on here. So what the restraint people were saying on the court in then is what they had been saying against the more active Supreme Court that was protecting property rights and freedom of contract from progressive legislation. What progressives had been saying against that is the judges should get out of the way of the Democratic majorities and let the Democratic majorities have their way. Well, Roosevelt eventually is able to name everybody on the Supreme Court because he serves 4 terms in office. And the Roosevelt appointees start to divide up. There are the original judicial restraint people who are still hewing to the original Progressive Party line that says judges should get out of the way of majorities. And then there are these new activist types who said, you know, the political use of judicial power is inevitable. This is Schlesinger summarizing what the activists think. The political use of judicial power is inevitable, so it ought to be used for good causes rather than for bad causes. You might even say for social justice. And it wasn't clear who Schlesinger himself was siding with. I think he was probably siding with the restraint people. But this is where we get the division from. Ironically, political conservatives got their commitment to judicial restraint from the progressives via those justices who became conservatives on the court relative to the activists like Frederick Douglass, I wish, one of my heroes, like William Douglas, or like Earl Warren or the rest of that court. And the conservatives looking around thinking, well, who are we for? Well, we don't like what the Warren Court is doing on criminal procedure and they're overriding state autonomy here or there. We don't like what they're doing, so we're going to favor the dissenters there. And the dissenters were these restraint people saying you should be exercising restraint. That just got brought into the conservative legal movement, I think partly without much reflection. Then what happened during the Reagan administration, during the second term of the Reagan administration, is Attorney General Ed Meese became Attorney General in Reagan's second term, and Reagan charged him with doing something about the Constitution. And so the Meese Justice Department started to become very active in promoting a commitment to the Constitution. And among those commitments, Meese gave a very famous speech to the American Bar Association, which was normally just kind of a fluff speech, but he actually made it a serious event. And in that speech, he basically argued for judicial restraint, but then he also argued for a return to what he called the original intentions of the framers. So now conservatism, from that point forward, became wedded to 2 different horses. They had like riding a team of 2 different horses, the restraint horse and the originalism horse. What is the originalism horse? That's the horse that says that the Constitution should be interpreted. Today it says, Constitution should be interpreted according to its original meaning, not the intentions of the framers, but according to its original meaning. And that means that if a law conflicts with that, it should be invalidated. That's not a bad thing. That's what judges are supposed to do. If a law is consistent with that, it should be upheld. But the measure should be original meaning, not restraint or non-restraint. But you can see these horses were somewhat in tension with each other, because to enforce the original meaning of the Constitution meant that the courts are supposed to strike down laws that were passed and supported by a majority in the legislature. That was their job. But that was in conflict with the restraint part of this thing. So in the beginning, I mean, I've been through the conservative legal movement since the beginning. I was, in law school before there was a Federalist Society. And in the beginning, the restraint people kind of had the upper hand. And the originalism part of this was like down here. It started moving this way, and then with the Affordable Care Act challenge that I was very much involved with, when we got all the way up to the Supreme Court, and we actually convinced 5 justices that our argument about Congress having exceeded its powers under the Commerce Clause was valid. We still lose the case because the 5th Justice, Chief Justice Roberts, exercises what? He exercises judicial restraint. And he says it is his duty to defer to the statute. He doesn't even say defer to Congress. I think he just miswrote that. He should have said defer to Congress. But he said, it's my duty to defer to the statute if there's any reasonably possible meaning the statute could be given that would be constitutional. And that's how we lost the case. Normally, if you win on the law, you win the case. We won on the law. We still lost the case. Why? Because of judicial restraint. I think from 2012 until now, the originalism side has been gaining ground and the restraint side has been receding. And this culminated in the Trump administration, where for the first time a Republican president's White House counsel and White House counsel's office was screening judicial candidates for their commitment to originalism. Prior to that, both Bush administrations had been screening for restraint and getting judges they didn't care for down the line. But it was the Trump administration for the first time that started screening for originalist justices and originalist judges. And we all can be the judge of how successful they were, but it was the first time they were really trying to do that. And it has represented a sea change. So what the senator was referring to as judicial engagement is just another word. It's not important what word you use. It's just another word for saying that judges should be actively engaged in evaluating whether the Constitution has been followed by the other actors in the government, or whether it has not been. And if it has not been, they should step in and say so. And if a case comes before them, they should not enforce a law that conflicts with the higher law of the Constitution, which is what Alexander Hamilton said in Federalist 78. Is that what
I think you've done a pretty good job.
Okay, thanks, thanks.
When we go to the students.
How about right over here? Oh, they have mics? Okay, I better go with where the mic, I'm going to go wherever you get the mic. You find somebody with the mic, but we'll start with you over here first. It'll take too long if I point and you run there.
Sir, nice to meet you. Good afternoon.
Tell me where you are and who you are and where you're from.
My name's Paul. I'm a cadet at the Air Force Academy. I'm a law major, so I resonate with what you're saying.
Great.
So the question I have is, how do you balance the downfalls of originalism against, I guess, the benefits of being a living constitutionalist? So, for example, in the confirmation hearing of Justice Barrett, she was asked something about super precedents, or she said something about super precedents, about how like cases like Brown versus Board of Education are so fundamental that you can't overturn them. And as an originalist, you can't get those cases, you can't get those precedents from an originalist view of the Constitution. So how do you balance that with a living constitutional mindset?
Well, thank you for adding the last part of your question, because it helps me answer it. I think you could already tell from the talks I gave you that I don't agree with that. I don't agree with that you can't get Brown versus Board of Education out of original meaning. I think you surely can. The Republicans who passed the 14th Amendment then went on to pass the Civil Rights Act of 1875. And they all believed that they had a power to do that. That barred discrimination in the provision of public accommodations. And that included inns, common carriers, even places of public amusement. Barred discrimination across the country, north and south. I mean, one of the cases that were in the civil rights cases, among the civil rights cases that were heard, was a case that arose in San Francisco. So it wasn't just about the South. Those Republicans who passed the 14th Amendment thought that provision barring discrimination in public accommodations, even privately owned public accommodations, were perfectly within their Section 5 powers to enact under the 14th Amendment. And I agree with them. And I think that Plessy was wrongly decided. And if you think Plessy was wrongly decided, then it's a very short step to thinking Brown versus Board of Education was correctly decided, because Brown is just the opposite of Plessy. And so that's part of what I say. You raise another question, which is also fundamental, which is what do you do about precedent, whether it's good or bad? And sometimes precedents are good, and lots of times precedents are bad. I think ultimately lower courts have to follow Supreme Court precedent, because they go by the name, they're called by the Constitution inferior courts, which means they're inferior to what? The Supreme Court. So they have to do what the Supreme Court says. So lower court judges need to follow precedent. The Supreme Court has never acted as though it actually has to follow precedent, to be completely frank. They follow the precedents they ultimately want to follow. They don't follow the precedents they don't want to follow. So I'm not all that impressed with anybody's commitment to precedent. I do think it tends to be invoked as a matter of convenience, not just because they like certain cases or not. That's not why they uphold precedents. That's not always why they like precedents. They like them in part because they feel if they overrule this precedent, it's going to get them into this other stuff. They don't want to go into this other stuff, and so they might as well just stick with the precedent. I think that is a shirking to some degree of the Supreme Court's responsibilities. On the other hand, I also want to be clear. I only think that justices should reverse precedents when they are clearly in violation of the original meaning of the Constitution. And many, many, many precedents are not, for a variety of reasons that I don't have time to go into. Most are not inconsistent with the Constitution, but when they are, it is the duty of the court to follow the higher law of the Constitution, not the law made by dead justices. You talk about living constitutionalism is usually a pushback against being ruled by the dead hand of the past, by the dead white male founders. Well, following precedent is being ruled by the dead hand of justices, mostly male justices. And so if you're against being ruled by the dead hand, then you must be skeptical about precedent. And truthfully, most progressives don't give a hoot about precedent when their turn comes to control things. That's what the Warren Court did. They overturned precedent after precedent after precedent, and that was hailed by progressives in academia and outside of academia as a great step forward.
question is, given your framework for interpreting the Constitution, this sort of originalism that you brought up, how would you evaluate some recent conservative Supreme Court justices, so Scalia, Thomas, Kavanaugh, Gorsuch, in that sort of framework?
I know all of these people, and I like all of these people, and I'm not going to trash any of them today. But I do think some are a little more stalwart than others. I actually went a little far. I was the lawyer representing Angel Raich in the medical marijuana case called Gonzalez versus Raich, which none of you have heard of, but you all will read when you go to law school, because it's a standard case in the case books. It has to do with medical marijuana that the state of California said was legal and the federal government said was not, and I was the lawyer for Angel Raich, challenging the constitutionality of applying the Controlled Substances Act to activity that was legal under state law in this way. And Justice Scalia ruled against us. We lost the case 6-3. We got Justice Thomas. I'll just say once more, we got Justice Thomas. I'm not going to say good things or bad things about anybody, but we got Justice Thomas. We got Justice Rehnquist and we got Justice O'Connor. We lost Justice Scalia and we lost Justice Kennedy. And after that, I was sort of a little bit frustrated with Justice Scalia, and I wrote kind of a scathing article for me in a law review article. That was like the only payback I can have is, a scathing law review article. That's all I could do. I kind of wish I had tempered my rhetoric a little bit. I think he was deeply wrong, but I think I went a little too far in my tone. And actually, when his son, I got to know his son Chris after his passing, and I was somewhere with Chris socially, and we got along really well. And somehow he came across this article, and so he asked me about it. I said, Chris, I just have to say, I think I was a little intemperate when it came to your dad in that article, and I wouldn't write it that way again if I had it to do all over again. So that made him feel better.
I would like to ask a question about narratives and what kind of arguments conservatives should be using, because there's also a certain critique of liberalism that is coming from the right, from people like, the big name is Pat Deneen, although
I know Pat Deneen.
But people like Pat Deneen or Alistair McIntyre, these kinds of people who do have a critique of liberalism from the right. And I'm just wondering if you have a critique or a response to that kind of argument.
Well, I do. The most recent proponent of this is a Harvard law professor named Adrian Vermeule, who wrote a piece in The Atlantic arguing in favor of what he called common good constitutionalism, and really against originalism. I made an allusion to him without naming him in my comment about recently conservatives have been pushing back even on originalism. I wrote a response that's also in The Atlantic, so if you Google me and Vermeule in The Atlantic, you'll get both him and then you'll get my response. And I can't really go into all of it now, only to say that to the extent the argument, I'm going to limit myself because there's a lot of things I could say, but to the extent the argument is that judges should be pursuing the common good as opposed to following the original meaning of the Constitution, which is what he argues for, I say that the Constitution, if it's a good Constitution, which I believe it now is, I don't have to defend the original Constitution, I only have to defend the amended Constitution, that's the one we've got. If the Constitution is a good Constitution, insofar as it actually, if followed, would secure individual rights, that is a means to the common good. That is, it's one thing to say you're for the common good, it's another thing to say what is the common good and how do we get there. The liberal conception of rights, natural rights, is that rights are not an end in themselves. Rights are the means by which individuals can pursue happiness, by which we mean flourishing, human flourishing, which should appeal to Professor Deneen. The reason why individual rights are the ways in which individuals can pursue human happiness, flourishing, or an Aristotelian good life, while living in close proximity with other individuals who are also charged with doing that, who also have to do that, under circumstances where one person's activity can interfere with the pursuit of other people's happiness. So you need to have boundaries within which individuals can pursue happiness so they don't get in the way of other people pursuing happiness. Those boundaries are defined by natural rights. So another way of looking at natural rights provide the boundaries within which individuals can pursue happiness according to the natural law, if you believe in natural law, as a way of guiding how we should how we should conduct ourselves, more morally conduct ourselves. So natural rights are not inconsistent at all with the natural law. Natural rights are not inconsistent with human flourishing, and natural rights are an absolutely essential prerequisite to achieving the common good. Because remember, the common good is supposed to be common to all of us. Natural rights ensures that each and every one of us, gets counted in that calculation of the common good and not sacrificed for the higher public good that requires some of your sacrifices in order to achieve the goods of other people. Anyway, I said I was going to be short. I wasn't short. It's a big question. And you're right to say it is roiling conservative circles right now. This young lady over here.
Hi, I'm Rachel Baker. I'm interning with Senator Sass. So I have a question kind of going off of that. What is one
So did you appreciate my shout out to Senator Sass in my talk?
Yes, I did.
Okay, you'll have to tell him I gave him a shout out in my talk.
What is one solution you see when it comes to balancing the social justice movement that we're seeing currently and these natural rights that you're talking about?
I didn't catch the beginning of what you said.
What is one solution you see when it comes to balancing those two things?
Yeah, look, I thought you were going to, when you asked me about narrative, you started with narrative. I thought this is where you were going to go, and then you took me off to Patrick Deneen land, which, that's for whatever good it was that we did. I think you need to tell a story. People are influenced and committed by stories. They're not really convinced by logical deductions from first principles. I think logical deductions from first principles are super important. They're the way we check ourselves so that we don't go off the rails. But people are influenced by stories, and the left is telling a story. That's what this is all about. That's what this whole thing is about. They have a story to tell. They've been telling the story for a long time. They've been telling the story since I was your age. But now they've got some traction. They have managed to work their way through their elite institutions. And their story, which used to be more of a marginal story, is now being a central story. And part of the reason for that is we have failed in educating people on their actual story. And our actual story is a great story. It is not a utopian story. It is not a story in which right always wins out. It's a story that was very, very costly and involved a lot of struggle. But it's a story that puts us in a better place today than we have ever been before. And that is important. It's a story of improvement as opposed to a story of triumph. And we need to tell that story, but we need to learn it ourselves for the first time. You need to read about anti-slavery constitutionalism. You need to read who it was that was arguing for it and what they were arguing for. Law professors and historians dismiss their arguments in the words of one constitutional law professor, they were constitutional utopians. They were not. They actually had very, very compelling arguments. First among these people was Frederick Douglass himself, who became a constitutional scholar, who became a constitutional theorist. I should say theorist, not a scholar. He was a theorist. And it was very, very powerful. There's a new book out called Our Glorious Liberty by Damon Root, who I know the senator is a fan of Damon's, who previously wrote a book on judicial engagement, as a matter of fact. And it's a fantastic read on Frederick Douglass and his fight for the anti-slavery Constitution. Now, he was not alone. It turns out there were dozens of them. I wrote my stuff. I discovered one after the other. There are historians who do know about these people. I'm not the first person to discover them, but most historians don't take their constitutional arguments seriously. And it was their constitutional arguments that got enshrined into the Constitution in the form of a constitutional amendment. 3 of them, the 13th Amendment, the 14th Amendment, and the 15th Amendment. They won. It ultimately led to their arguments led to the formation. First there was the Liberty Party, a purely anti-slavery party. Then there was the Free Soil Party, a more moderate party than that. And finally there was the Republican Party. And Chief Justice Salmon Chase was the author of the constitutional platforms of all 3 of these parties. And they won. And then they put their views into the Constitution in the 14th Amendment. You'll have to read my book to see how that happened, or what they actually put in there. But start with Damon's book. This is a story, I just can't believe hardly any of you have heard this. And this is, I'm not making this up, and this is something that, as I say, historians know about the facts, they just don't understand the legal theories that were being advocated. And the idea that the 14th Amendment was a product of anti-slavery constitutionalism, that became popular like in the 1950s, and then it kind of died out as a marginal theory.
But Randy, you know what the left response to this is? Very short. They just say, oh, that may all be true, but the party switched places.
No,
That's their shorthand. The Republicans don't deserve any of your history because somehow the parties changed places.
But remember, I mean, that's a different subject, the switch in the parties, that's a different subject. This was not a brief for today's Republican Party. This was a brief for the historical narrative of the United States of America, in which the Republican Party played a crucial role. This is an argument for why conservatives and libertarians, and what I call conservative constitutionalists, need to pay as much attention to the Republicans in the 39th Congress as they do to the founders in Philadelphia, because they're responsible for what has justly been called our second founding. They made an important amendment, three important amendments that changed our structure of government for the better. That's an important part of our story, and that's all I'm arguing for. And Democrats can say what they want about how racist their current party is versus how racist their previous party was. They were the party of Jim Crow. They were the party of slavery. They were the party of Jim Crow all through the entire, through my lifetime, they were the party of Jim Crow. They were also the party of the Republican Party, the party of the Civil Rights Act of 1964 and 1965, for which they deserve great credit. It is true, as Republicans like to say, that a higher percentage of Republicans in both the House and Senate supported the Civil Rights Act of 1964 and 1965 than did Democrats, but they were a small minority. Without the Republicans, it wouldn't have passed, but the Democrats were in control, and they passed those laws, and they're to receive full credit for that. Query the degree to which they are still committed to what those laws say today. The laws could be good, and they could have a very living constitutionalist or living interpretation of what those laws actually say and what they forbid, which might actually end up not being so good. But that's a subject for another lecture at another time.
Hi, I'm just curious what your stance is in the Supreme Court's role in the election integrity in 2020, and what you would say the constitutional, the originalist viewpoint for whenever there's a misunderstanding or where it comes to viewing the Constitution.
Well, you sort of trailed out there at the end. You want to
The original.
give him the mic back.
What the originalist viewpoint is to whenever there's a misunderstanding, whenever liberal justice views their stance on the Constitution.
On the Constitution. All right. As for the election, I don't have a strong view on the election. I don't think we know that much about what happened during the election. We're not, for a variety of reasons. So I don't have a very strong view on that. I do think that there were some serious legal issues raised in Pennsylvania, for example, by the fact that the Supreme Court there, after lawsuits, changed Pennsylvania election law in advance of that election in a way that seemed to violate the Pennsylvania Constitution. But beyond that, I don't have a very strong opinion and I certainly don't have an originalist opinion about that. By the way, one of the disadvantages of being an original, one of the great things about being a living constitutionalist is you can have a constitutional opinion on everything. And your constitutional opinion on everything is, if I like it, it's constitutional. If I don't like it, it's unconstitutional. And then I just have to marshal the strongest arguments on behalf of the conclusion I already know. That's fun. That's great. If you're an originalist, you have to sit back and you have to look at the text and you have to think and then you have to do some research into what it might originally mean, and that all takes work. So it's a little harder, and it means that you don't have opinions about everything. And so so what I do is I have opinions about the stuff. I'll give you an example. So I just testified last week, 2 weeks ago now, before the President's Commission on the Supreme Court, which is studying court packing and other proposals. And I have my view about what the purpose of this commission is as a practical matter, why it was set up and what it's going to do, but I'll put that to one side. So I was on the panel on court packing to testify. So I wrote up my testimony, and I started working on this, and I started saying, well, I think court packing is a bad idea. Everybody agrees that court packing is permissible, but I think it's a bad idea, and I was about to write up all my things. So I decided to say, but before I did that, I thought, what is the authority? What is the constitutional authority for? The reason why people say court packing is permissible is because Congress sets the number of justices, and it has always set the number of justices. At some point it was as few as 6, some point it's been as many as 10. For 152 years it's been 9, but Congress sets the number. So it seems perfectly constitutional for Congress to change the number, right? No problem. That's what everybody thinks. That's what conservatives think. They don't like the idea, they're opposed to it on policy grounds, but they think it's constitutional. But I started thinking, I said, and this is something I do know about, what is the law, what is the part of the Constitution that gives Congress the power to set the number of justices? Well, there is no express power to do that. It's the Necessary and Proper Clause. And what does the Necessary and Proper Clause say? It says Congress shall have, at the end of all its enumerated powers, it says Congress shall have power to make all laws which shall be necessary or proper for carrying into execution its foregoing powers and the powers that are residing in the other departments or offices that are created by the Constitution. And by department, they're referring to it includes the judicial department, which is the judiciary, Article 3. So they get to use the Necessary and Proper Clause power to carry into effect the judicial power in Article 3, and that's perfectly fine. But what does the clause say? It says that such a law must be both necessary and it must be proper. And it turns out there's actually law on that, including NFIB versus Sebelius, the good law we made in that case when we got 5 votes that held that an individual insurance mandate might be necessary to the Affordable Care Act, but it was not a proper exercise of congressional power. We got 5 votes for that. So when I started evaluating, I realized that it's one thing for Congress to set the number of justices. Once they set it, however, it's another thing for them to change the number to secure a partisan advantage on the court, to change the number to affect how the court rules. That is not a legitimate end. And what John Marshall said in McCulloch versus Maryland, the most famous Necessary and Proper Clause case there ever was, is the beginning of his test for the Necessary and Proper Clause is let the end be legitimate. Let it be within, wait a second, let the end be legitimate. Is it a legitimate end for Congress to change the number of justices, to get the justices to change how they're ruling? My argument was it's not, and not only that, but it's an improper law because it violates the separation of powers to have Congress do this. So I told the commission this, and I said, look, I understand there's a lot of fancy lawyers and smart law professors among you, but law professors are very quick to dismiss arguments that they didn't think of themselves when they hear them for the first time. So don't be so quick to dismiss this. And remember, it's not just up to the courts to decide what's constitutional. It's up to Congress. It's up to each individual senator to decide what's constitutional. And in the Senate, there is a procedure. Every senator has the privilege of raising a point of constitutional order when a law is passed, when a law is proposed. And that was done in the Affordable Care Act case with the Affordable Care Act, and that means there was a debate and vote on the constitutionality of that law in the Senate the day before the bill came out of the Senate. It was on December 23rd, 2009. So I predict if a court packing bill emerges, there will be a debate on the floor because I believe at least one senator will raise a point of constitutional order, and then there will need to be a floor debate, which will be publicized. It will be on C-SPAN in the whole country like they did last time. We'll get to hear the reason why it is unconstitutional to change the number of justices in order to affect the outcome. When the number of justices has been changed in the past, the last thing I'm going to say about this, because this is a big topic. When the number of justices were changed for the past, with all but 2 incidents, they were changed to reflect the number of circuits because justices were charged with being the appellate courts. There was no court of appeals. So you had the justices rode circuit and they served on the appellate courts within the circuits. And as Congress added new states, they added new circuits, and then they added new justices to match the new circuits. There was an ideologically, politically neutral reason for why they had to expand the number of justices. There were 3 occasions in which court packing was tried. One was The Federalists cut back the number of justices to stop President Jefferson from appointing a justice, and that failed when the Republicans took the control of the election, restored that seat, and he made the appointment. The second try, the most recent try was Roosevelt when he tried to do it, and that got rejected as unconstitutional by the democratically controlled, overwhelmingly democratically controlled Senate, and I quoted from the report that the Democrat senators had issued as to why it was unconstitutional. And then there was those two failed. There was a successful example of court packing, which is when the Republicans cut back on the number of justices that Andrew Johnson, who was thwarting their efforts to fight for the freedmen and against white supremacy, they didn't want him making justice appointments that would obstruct their civil rights agenda, and so they cut back the number of justices, and when Grant gets elected, they restored that number. That was successful court packing, the only time it's been done successfully. That doesn't make it a norm. It's been a norm for 150, it was a norm before that, and it was a norm for 150 years after that, that doing that for that reason is not an appropriate reason for doing it. And there was actually no retribution taken by Democrats because Johnson was such an odd person out. He was not a Democrat. He was not considered to be a Democrat, nor was he a Republican. He was Lincoln's vice president. And so the Democrats, when they came into power, they didn't do anything in retaliation for what the Republicans had done to Johnson.
To Randy's point on the constitutionality, the last time it was raised in the Senate was during the impeachment, the last impeachment of President Trump. I raised the question, is it constitutional to impeach a former president? I lost, but that was done at the very beginning, and I lost with 41 votes in favor, so everybody knew from the outset that there wouldn't be an impeachment. So I lost the case, but won overall in the sense that 41 people didn't believe you could impeach a former president.
And thank you for that, Senator. And also, we also won while we lost on the Affordable Care Act. We won because at that point, the argument that at this point had just been mine and a couple other people that we made at the Heritage Foundation was launched into the public space by the U.S. Senate. And it was from that date forward that it became a big public issue as to whether the Affordable Care Act was constitutional or not. So by the time the bill actually passed, it finally passed the Senate and the House on March 23rd, multiple state AGs, eventually 25 state AGs, 26 state AGs, filed constitutional challenges to it the next day after it was enacted. Okay, this will have to be the last one, so who wants to make it a good one? It's got to be a really, okay, this guy looks like he's primed.
I'm primed.
He's primed.
Hello, my name is Lucas Baker.
Where are you from?
I'm from Minnesota.
Minnesota.
And I go to the University of St. Thomas in Minnesota. Thank you very much. My question is on the 17th Amendment. My question is, do you think that, first off, what are your thoughts on it, and then second off,
Tell everybody what the 17th Amendment, you raised it, you got to tell them what it is.
The 17th Amendment changed the rules of the election of senators. Before the 17th Amendment, senators were elected by state legislatures. After the 17th Amendment, they became directly elected. So my question is, what do you think about that? And then second off, do you think that the repeal of that amendment is essential or important to protect federalism, or if it should be repealed?
Great. I was just telling the senator about this on the way over here. I actually am, I have the distinct privilege of being one of the only law professors who had a constitutional amendment introduced into both houses of Congress many sessions ago, before he was in the Senate. It was about somewhat on this topic, and I'll say what that amendment was as soon as I answer your question about the 17th. All right, so I get an awful lot of questions about the 17th Amendment and whether that has substantially changed our federalism. It does. It has changed our federalism in the sense that senators used to be a creature of the states, and now they're a creature of the populations of the states. They used to be a creature of state legislatures, I should say. It's state legislatures that sent them there, not the people of the state, but the state. And that meant state legislatures in the interests of the state governments could be accounted for in the U.S. Senate, which is much, much less true today, given that senators stand for popular election. It was how Charles Sumner went to the Senate as an anti-slavery senator from Massachusetts. He didn't stand for election. He was sent to the. He ran for election. He ran as a free soiler. And he was chosen by the Democrats in Massachusetts because the Free Soilers held the balance of power in Massachusetts versus the Whigs, and he gave the Democrats the edge, and they sent him to the Senate where he could be an anti-slavery vote. And Salmon Chase from Ohio, who ultimately ended up being Chief Justice of the United States, same thing happened in Ohio. He made a deal with the Democrats not only to send him to the Senate, but to repeal the Black Code in Ohio. They accomplished, the Free Soilers accomplished both those things, but it was the legislature that did this. This tells you something about how people got to be senators, however, which is they were deals made in the legislatures. And I'm not so sure how optimal that is, frankly. And it was unpopular, and it became unpopular long before the 17th Amendment was passed. You all have heard about the Lincoln-Douglas debates in which they're running for Senate. Well, back when they were where President Lincoln was debating against Stephen Douglas, there was no, the legislature would send them to Washington as senators, but there still was a plebiscite that the Senate would follow. So state by state, they were basically picking people that, not every state, but they were tended to be picking people that were elected by plebiscite anyway. But that doesn't mean that there shouldn't be a state check on federal power. The 17th Amendment, I think, just would not provide that good a one. A better one was what I call the Repeal Amendment that did get introduced by Senator Enzi, who I was just told on the way over here passed away as a result of a bike accident, which I'm shocked to hear about, and Congressman Rob Bishop from Utah in the House. They both introduced this into Congress, and what this amendment called for was a majority of state legislatures could vote to repeal any federal law or regulation. So if 2/3 of state legislatures decided that a law or federal regulation should be repealed, it would be repealed. Now, Congress could pass it again, but lots of times these things that get objectionable are parts of larger bills and they wouldn't stand on their own 2 feet. They wouldn't get passed again. But this is a way for states to actually have a meaningful role to play. There was a movement a small movement in favor of this, which is how it got introduced in Congress, and I did a lot of TV. I did a CNN show with Eliot Spitzer. When Eliot Spitzer had a show, I was on his program in New York debating Eliot Spitzer about this. He's a disgraced former Democrat, just for those of you who never heard of who Eliot Spitzer is. Google him. Anyway, but it wasn't a movement that had much funding, and it kind of dissipated and went away. But it was fun, and it's the kind of constitutional amendment that I think is best. The best constitutional amendments are structural amendments, not substantive amendments. This is what I'll leave them with. This is the last thing I'll say. A substantive amendment will tell to the government, thou shalt not do X. And then you have to rely on the courts to enforce it. And guess what? The courts don't do a great job of enforcing these things. We want them to do a better job. That's my job, to try to get them to do a better job, but they don't do a great job. It's more effective to have a structural amendment in which the government's our power is being limited from within. And so that's why the repeal amendment didn't say anything should be repealed. It just said we're going to empower 2/3 of the states to check federal power. Because of the 14th Amendment, the federal government now has a power to check states from abusing the rights of their citizens that they didn't have at the founding, and which was one of the defects of our Constitution at the founding. But what we don't have is a corresponding effect, a check by the states on the federal government, and that's what we could use. So we don't have a perfect Constitution. What we have, I think, is a Constitution that's worthy of respect and which will actually lead to the common good if it's actually followed. And that's the challenge for you in the future, to get us to the point where we will have justices and judges and senators and congressmen who will actually follow the Constitution of the United States, which protects the rights of each and every one of us. Thank you.